Welcome everyone, and thank you for joining us today on Level Up Law, where every Tuesday at noon, we level up your legal knowledge on one of the areas of law where we represent clients. I'm Susan Ingalls, Senior Staff Attorney with South Carolina Legal Services, and today I'm joined by Attorney Charlotte Osmer of our Greenville office. Charlotte is going to level up your knowledge on the law of adoption in South Carolina. We are recording this webinar and we'll post it to our YouTube channel later this week, along with the slides that Charlotte will be using today and some helpful links to forms. We will have the audience in listen-only mode during the presentation, but be sure to put any questions that you have in the question box. Now, Charlotte will be going over some frequently asked questions towards the end of her presentation. So you may want to wait until you've heard those because she may answer your questions during the presentation. Please keep in mind that Charlotte can only provide general information for the public, and so this is not legal advice. You should always consult with an attorney for any specific legal issues or questions that you have. At the conclusion of today's presentation, we will provide all of the contact information to apply for free legal assistance at South Carolina Legal Services. Again, thanks so much for joining us. There's a lot of information to cover, so I'm going to go ahead and turn things over to Charlotte so she can get started. Charlotte?
Thanks so much, Susie. So thank you to everybody for joining us today. We're going to be talking about adoptions, and I just wanted to say thank you to Susan Ingalls, Anitra Hardy, and Kenneth Elliott for here at Legal Services for putting this whole series together. We wouldn't be here today without all their wonderful assistance. So before we get started, I feel that adoptions are a pretty personal issue for many people, so we just wanted to take a moment and poll our attendees and see if they are personally familiar with adoptions, whether you were adopted, you have adopted a child, whether you know somebody who's been adopted, or you're just thinking about adoptions. For us, adoptions didn't work out, so that's why here at Legal Services, every time I have an adoption case, it is just such a wonderful and rewarding experience. It's such a momentous and joyous occasion. It's a long and tedious process, so once you finally get to the end and get that adoption finalized, it is just really wonderful. So is that enough time for everybody to have answered this question? Okay, well, we can go ahead and see those results in a little bit later. We'll go ahead and get started with this presentation. So today we're going to go ahead and talk about adoptions. We're going to talk about what is adoption, the types of adoption here in South Carolina, who can adopt, who can be adopted. We're going to talk about what it is to terminate the biological parent's parental rights. We're going to talk about the adoption process. I'm also going to talk about some frequently asked questions that I receive from my clients in adoption cases. And so far, we've already received a couple of questions before today's presentation. So I'll go ahead and answer those, and then any other questions you may have during the presentation. So adoption is the judicial act of creating a relationship of parent and child where it did not previously exist. So this is a permanent change in status. That child's birth certificate is going to be amended. It's going to remove the biological parents from the birth certificate, and it's going to add the adoptive parents as the biological parents. Usually now, if your adoption has been granted, it's because the adoptive parents have been deemed to be the fit and proper people to care for the adoptive child. They're the ones who are going to be caring for that child's welfare, and they're going to provide a suitable home, an environment that provides love and care, and that is necessary for a healthy and productive life for that child. So there's many different types of adoption here in South Carolina, whether you have a private agency adoption, international adoptions, surrogate adoptions, foster care adoptions. We also see a lot of relative adoptions, and it's also possible to have non-relative adoptions where the child has already been where the child may already be residing with the adoptive parents. So here at Legal Services, we mostly handle the relative adoptions and those non-relative adoptions of children who are already residing with the adoptive parents. So who can adopt? The definition here in South Carolina is very broad, and so it says that any South Carolina resident may petition the family court to adopt a child. So that seems very broad. There are many, many steps involved in adoption, so this is just saying who has the initial potential to initiate an adoption. So there's many things to consider prior to the adoption. Both married and single people can adopt. You just have to be of legal age. U.S. citizenship is not required, but you have to take into consideration financial, housing, and health. So you have to be able to financially provide for the child. You must offer enough space and ensure the health, safety, and well-being of the child, and take into consideration any physical and emotional health issues that the child may have. As far as who can be adopted, the law says any child present within the state at the time the petition for adoption is filed, regardless of the place of birth or place of residence of the child. So here at Legal Services, like I said, mostly we do step-parent adoptions, or in most cases, it's because DSS has removed the children from the biological parents due to abuse or neglect and placed the children with relatives. That's going to be the primary case that we see. Unfortunately, a lot of those cases is because the child tested positive for drugs at the time of birth, and therefore that's the primary reason that DSS has removed the children from the biological parents. So in order to initiate the adoption process, you first have to terminate the parental rights of the biological parents. As far as you can, that child has to be deemed legally free for adoption in order to pursue the adoption. So there is a law and procedures in place here in South Carolina in order to terminate parental rights where the children are abused, neglected, abandoned, in order to protect the health and welfare of these children and make them eligible for adoption by persons who will provide a suitable home environment and the love and care necessary for a happy, healthy, and productive life of that child. So there's two ways to terminate parental rights. You can do it consensually, and that means that the biological parents are coming forward and they can consent or relinquish their parental rights for the purpose of the adoption. If it's non-consensual, that means the family court has to step in to terminate the parental rights of biological parents if grounds exist to terminate the parental rights and there's a finding that it's in the best interest of the child. So if the biological parent is willing to consent to the adoption, it has to be very specific how it has to be done in order to comply with the statutory requirements. I get a lot of clients who say, well, gosh, no, I got a text saying from the biological mom that she's willing to consent, or she signed this piece of paper in front of a notary that says that she consents to the adoption. That is not a valid consent to adoption. It has to be a sworn document signed by the biological parent giving consent, and in the statement the biological parent is explicitly stating that they forfeit all rights and obligations to the child. Now, one of the reasons that a lot of biological parents might be willing to sign this consent to adoption is because they've been ordered to pay child support, and they might be placed in jail for not paying child support, or it's being deducted from their paycheck, or they just don't want to deal with the hassle of the continued child support. So it's important to note that this voluntary consent to adoption includes any future child support obligation that will be terminated once the adoption is finalized, but it does not relieve any obligation to pay child support or rearage. Only a court can order this. So if any biological parent is looking to do this just because they don't want to pay the child support ongoing, or if they have anything outstanding, it only terminates the ongoing obligation. It does not relieve the obligation to pay any child support or rearage. That would be done separately. This would just be alone with the voluntary consent to adoption. Those biological parents are entitled to legal representation, and it must be signed in the presence of two witnesses, one of whom must typically be an attorney, and you have to attach a specific certification that the voluntary consent to adoption was properly complied in once it was executed. So can this voluntary consent to adoption be withdrawn by the biological parents? So prior to the finalization of the adoption, the biological parent is able to withdraw it, but only if it's in the best interest of the child and they can prove that the consent was not given voluntarily or it was the product of duress or coercion. So after the finalization of the adoption, the statute says that there's nothing to be done. However, there was one case law that made an exception, and that had to prove such an to prove extrinsic fraud is a very high burden. So that's the only common law exception. And that just means that a case law has interpreted the statutes and said that this exception exists, although the statute says that there is no exception. So court-ordered TPR, and I'm using TPR, that just means termination of parental rights. So in this situation, what we talked about, so either the biological parents can voluntarily consent to it, but if they don't want to consent, then you have to determine whether there are grounds for termination of parental rights. There are 11 grounds for termination of parental rights here in South Carolina. So each case has to be evaluated on a case-by-case basis to see if that TPR grounds exist. So the most common ones that we would see is for a child that has been abused or neglected, or the biological parents have committed willful failure to visit the child for 6 months, or they have willfully failed to pay child support for 6 months. So it's either the visitation is the most common, or the failure to pay child support for 6 months is the most common. So sometimes we think, well, gosh, it's been a long time since the biological parent has come to visit the child, but you happen to run into the biological parent at CVS, or you went to a family birthday party and the biological parent happened to be there and talked to the child for a couple minutes. That does not count. An incidental visitation like that will carry little to no weight. What's also important is that the adoptive parents can't use the ground to terminate parental rights for willful failure to visit the child for 6 months if they have prohibited the parents from visiting that child. So you can't have it both ways. So you're saying that maybe you have concerns or so, but you can't say, you know, if that biological parent is making an effort and wants to visit that child, but you are prohibiting that biological parent from visiting the child, then you can't use that as a ground to terminate their parental rights. After a ground has been identified to terminate the biological parent's parental rights, you also have to determine whether terminating those parental rights is in the child's best interest. And any biological parent is entitled to a court-appointed attorney if they cannot afford one. So we've talked about now the termination of parental rights. Like I said, you need to be able to, that child needs to be legally free for adoption in order to then start the adoption process. However, it doesn't mean that it has to be two separate court actions, and sometimes they are, but for the most part, I would do them at the same time. I would terminate the parental rights at the same time that I'm seeking the adoption. Like I said, you know, it can be evaluated on a case-by-case basis, but for the most part, I would go ahead and do the termination of parental rights and at the same time seek the adoption in the same court case. So we have consensual versus non-consensual adoptions. So the consensual adoption is where the biological parent has signed that voluntary consent to adoption that we just talked about. So when that happens, in that voluntary consent to adoption, the biological parents have explicitly stated that they do not want to have anything to do with the adoption court proceedings. So when that's the case, you do not need to name the biological parent in the adoption proceedings, and you do not need to serve them or give them notice of the adoption proceedings, which makes things a lot easier. In that case, then it's uncontested, meaning there is no opposing party listed in the adoption proceedings, and it makes things go a lot quicker and a lot smoother. In non-consensual adoptions, that means you did not obtain a voluntary consent to adoption from the biological parents. Then you have to name the biological parents in the adoption action. You have to serve them with a notice of adoption, and if they want to, they can go ahead and contest the adoptions. So when I'm talking about consensual versus non-consensual, it just means whether they signed that voluntary consent to adoption or whether you need to go ahead and terminate their parental rights in court at the same time that you're going to pursue the adoption. So this doesn't mean sometimes my clients say, well, if I have a grandparent who's doing the adoption, it says, well, the biological parent is not opposed to the adoption, therefore it's consensual. It just means that in that situation, they still need to be named. If they have not signed that consent to adoption, they're going to need to be named in the adoption action, and they're going to need to be served. That doesn't mean they have to come to court, doesn't mean they have to contest it. They just have to be provided notice with it. So sometimes we just have situations where the biological parents might have a warrant out for their arrest, and so they are afraid to leave their home, or they're afraid to go out of the county because they might get arrested. We have other biological parents who are so far gone on drugs that they just can't be bothered to leave their home and come sign that voluntary consent to adoption. But we'll have to, so even though they might not oppose the adoption, we still have to name them and serve them with notice of the adoption. So what if the biological father is unknown? This is something that happens frequently. So one of the first things I ask my clients to provide is the child's birth certificate and any sort of legal documents related to that child's custody. Like I said, most of the cases we would have, DSS has already been involved, and so therefore legal custody has already been granted to the adoptive parents. That's not always the case, but that usually is the case. So if the biological father is unknown, then you have to move forward with the responsible father registry. So before 2010, if you didn't know who the father was of the child you're seeking to adopt, then you had to serve John Doe, and that made things quite difficult. So now, effective 2010, to receive notice of a TPR or an adoption, a man who has potentially fathered a child with a woman in South Carolina to whom he's not married must record his name with a registry. So failure to register under the registry does not constitute a biological father's consent, but it's just a waiver of his right to notice. So this is one of the first things that when I receive a client, the child's birth certificate and there's no father listed on there, the first thing I'm going to do is run the responsible father registry. And here is what the certificate of diligent search says. This says, for example, there's no claim of paternity. So just because you don't know who the biological father is, there's nobody listed on the birth certificate, and there's nobody on the responsible father registry, it doesn't mean that that's just over and you don't need to name a father. There are quite a few exceptions to this. So one of the exceptions is any men married to the mother of the child, whether they are the biological father or not, whether they're listed on the birth certificate or not. So in South Carolina, any woman who is married, whether she's been estranged from her husband for years or not, that husband is the presumed legal father under South Carolina law. Whether paternity has been established by court. So in a lot of these DSS cases, they've probably already named the biological parents, both mother and father, in the action, in the DSS action. So in some of those court cases and in some of those court orders, it'll establish paternity in those cases. A lot of times it does not. However, one kind of tricky paternity case that you might not think about is that when a court has ordered a man to pay child support, even though the birth certificate is not amended and it doesn't explicitly say that they're the father, that means that paternity has been established. So any man who is required to pay child support or has been ordered by a court to pay child support is the father for purposes of adoptions and TPRs. There's also acknowledged fathers, and this is also another exception where you would have to name a father in an adoption action. So any father who's living with a child or the child's mother at the time of the TPR or adoption, or who holds himself out as the father, fathers who support or have contact with the child, fathers who've been identified by the mother in a sworn written statement, or obviously any father who's been named on the birth certificate. So once you initiate the court action, a guardian ad litem has to be appointed for the minor child. And this could be a lawyer or a non-lawyer that's appointed by the court in family proceedings to represent the best interest of the child. So in an adoption case, I'm the attorney, I'm going to be representing the adoptive parents. The guardian ad litem is appointed to then represent the best interest of the child. So the guardian ad litem is going to investigate the adoption, they're going to do background checks, they're going to go ahead and do a home visit, and then report to the court whether the adoption is in fact in the best interest of the child. So there's relatives and non-relative adoptions. So the statute says that in order to move forward with an adoption, you have to do a pre-placement investigation and background checks. You have to do a post-placement investigation and an accounting. Those investigations, the pre-placement and post-placement investigations, have to be done by a certified adoption investigator that has been certified by DSS. And so that is another cost associated with the adoption. However, this requirement is waived for anybody who's a relative of the adoptive child or if is a step parent of the adoptive child. So going into what it costs to do an adoption, there is a lot of cost associated with it, especially if it's a non-relative adoption. So we talked about that pre-placement investigation and background checks, the post-placement investigation, guardian ad litem fees, having to search the responsible father registry, service of process fees when you have to serve notice of the adoption on the biological parents, and now, of course, all the legal fees associated with the adoption. So in certain cases, DSS will give $1,500 in a subsidy for special needs adoption. So this is just quickly, it's a 4-page application. This is just part of the first page, and it's just to give you an idea of what it looks like. And so you just have to fill out information about all the adoptive family. And so what is a special needs adoption in order to qualify for this $1,500 subsidy? So as you would think, a child having a physical, mental, or emotional handicap, or a child at risk of having a physical, mental, or emotional handicap. But for DSS, they also consider older children or children in sibling groups as special needs, whether or not they have any sort of physical, mental, or emotional disabilities. It's just the fact that it's much harder to place older children for adoption, and it's much harder to place sibling groups for adoption, and that's why they're called special needs adoptions. So if you are checking the box as a special needs adoption for a child having a physical, mental, or emotional handicap, you can see where it's starred there. You're going to be required to submit documentation in support of that claim. However, the category right below it, a child at risk of having a physical, mental, or emotional handicap, you might not know if a child already has any sort of disability. So for example, in cases where the child was removed from the biological mother because the child has tested positive for drugs at birth, that child could be at risk due to that prenatal drug exposure. So sometimes when the child's younger, you might not know any issues that child might experience as they get older. So if that child's only 2-3 years old, you might not know that they have a hearing disability or problems with their visions or any sort of developmental delays, and that might not develop until later. Or if there is sometimes if we know who the biological parents are and they have a history of mental health, or if they have hereditary issues that could be passed on to the children, that child could be at risk, and therefore you can just state what the reason is, but you would not have to provide any sort of documentation because obviously you don't quite know what that issue could be. You would only find that out in the future. So at the adoption hearing, it is completely confidential, it's in closed court, and there's no admittance of non-participants. So that means you have the family, you have all the legal representatives, the guardian ad litem. So here is a picture of a cute, adorable boy from Michigan who was being adopted and invited his whole kindergarten class to come join at the final hearing. So it was a very special moment. So here in South Carolina, as far as being closed, most judges would allow you to bring in any other additional family members. Like I said, it's a very joyous and momentous occasion. The judges love these cases. You can take pictures. And like I said, it's usually a very positive situation. In certain circumstances, clients ask me if they can bring the children that they're adopting to the adoption. For the most part, yes. However, if we're doing the TPR and the adoption at the same time, sometimes the child is old enough to understand what is going on. I would have that child removed from the courtroom for that period of time. We would bring another caregiver who would sit outside with them, just because they don't need to hear some of the things that are being alleged against their biological parents. But certainly for the conclusion of the hearing, we would certainly bring those children in. So once the adoption is finalized, you need to amend the birth certificate to reflect the adoption. So this is the certificate of adoption that needs to be submitted to the Department of Health and Environmental Control here in South Carolina for children born in South Carolina in order to amend the birth certificate. So the first top part of the form will be completed by the attorney, then signed by the adoptive parents, and then the clerk of court completes the bottom part. So once this is submitted to DHEC with the certified copy of the final order, then the birth certificate will be amended and it will remove the biological parents from the birth certificate and then add the adoptive parents as the biological parents. So the sealing of adoption records. So adoption cases here in South Carolina are completely confidential, and they are sealed once the case is finalized. And so it can only be opened again for good cause. So I always tell my clients when I give them their certified copy of the final order to keep it in a safe place, because they just won't be able to walk down to the courthouse and get another copy of the certified copy of the final order. You got to make sure you keep it, in a safe place. So there have been a couple of times I've had to reopen adoption records, and in one situation, the attorney never submitted that certificate of adoption to DHEC to have the birth certificate amended. So the child started using his adoptive name, and then it turns out it didn't match his birth certificate. So he was having trouble getting ID because he could not prove what name he was using now, his adoptive name, but his birth certificate still listed his birth name. So that was considered good cause for opening it up and getting another copy of it. But you have to keep in mind that the adoption records will be sealed, and it can only be reopened for good cause. So these are some of the frequently asked questions that I get from my clients when we start the adoption process. And so one of them is, they say that they already have legal custody of my grandchildren. What is the difference with an adoption? So most of our cases we have with grandparents is that the DSS has intervened because, let's say, the child tested positive for drugs at birth, was placed with the grandparents, and the grandparents have been raising this child for years. So what would be, what if they already have legal custody, why would they want to do an adoption? So legal custody gives does not change the birth certificate. The biological parents remain the biological parents. And so legal custody allows those grandparents to make medical, health, educational, financial decisions for the children. However, they can be changed. It's not permanent. So if those biological parents get their act together, they get clean, they get stable housing and employment, they can petition the court to get custody back of their children. Not that there's anything wrong with that. So with the difference with the adoption, though, once the adoption is finalized, it's permanent, and the grandparents would then become the biological parents for purposes of the adoption on the birth certificate. So legal custody is not permanent, whereas the adoption is. The next question I get is, isn't TPR automatic if the biological parents don't comply with a DSS parenting plan? So these are for cases where DSS, again, was involved in removing the children from the biological parents and placing them with a relative. And so at those court hearings, the relative probably hears the judge or the guardian ad litem or the attorney tell those biological parents that if they don't comply with their parenting plan, if they don't visit the child for 6 months, if they don't pay their child support, that they could be subject to termination of parental rights. A lot of my clients think that that means it's automatic. Well, they haven't been around for a year, they haven't paid child support for a year. Isn't the termination of parental rights automatic? It is not. You have to do a separate action to move forward with that. Just because the grounds exist to terminate the parental rights, it does not mean that it's automatic. You have to go to court, and the court has to adjudicate whether there are grounds to terminate parental rights and whether it's in the child's best interest. So one of the other questions I get is, I don't know where the biological parents are. How would I give them notice of the adoption? So this is a great question. So just because you don't know where the biological parents are, and this happens all the time here at Legal Services, doesn't mean that you're restricted from going forward with the adoption. So you would have to get the last known address for the biological parent. And that, even if that means the last known address you have from them is 2 years ago, 3 years ago, you have to attempt service at the last known address for the biological parents. When you can't serve them at their last known address or anywhere else, then you have to petition the court for special permission to serve the biological parents by publication. And so you have to prove to the court that you've made every effort to locate the biological parents first. So here at Legal Services in our Greenville office, we have an amazing paralegal, Kathy Rogozinski, who's such a great investigator, and she checks property records and court records and public records and social media, and she provides a great history of the due and diligent search efforts we made to locate these biological parents. With that, then I go ahead and file a motion with the court, and then only once the court allows me to serve by publication can we move forward by serving by publication. And as you've seen in newspapers, it's those legal notices. It has to be published for 3 consecutive weeks in the county where the biological parent was last known to reside. So that's another way. So just because you don't know where the biological parents are doesn't mean you are restricted from moving forward with the adoption. Another question I get is saying, I didn't have to pay for the guardian ad litem in the DSS case. Why do I have to pay for the guardian ad litem now in this adoption case? So in the DSS case, that case includes, that's brought by the state of South Carolina through the Department of Social Services. So they pay for all costs and fees associated with that action. So unless DSS is bringing the adoption action, then the person who is seeking the adoption is responsible for the costs and fees associated with the adoption. So is there any economic benefit to doing an adoption? Absolutely. So in a lot of our cases, we have grandparents who are receiving Social Security benefits. By doing the adoption, then that once it's finalized, that grandparent can go to Social Security and say, I have a minor dependent. And so let's say the grandparent is receiving $1,200 a month in Social Security disability benefits. Because now that grandparent has a minor dependent, they can get up to 50% derivative benefit for that grandchild. So before, if their household income was $1,200 on that Social Security disability, now they can get about $1,800, which is a huge economic benefit by doing the adoption. So however, it doesn't mean that if you're adopting 3 grandchildren, you'll get $600 for each of them. It's just going to be $600 whether it's 1 child or if it's 3 children. The adoption derivative benefit is going to be the same. We also have a situation with, we had a step parent who was seeking to do the adoption, obviously because they were very close and so forth, but the economic benefit in that situation would be the step parent would then be able to add the stepdaughter on his health insurance through his work. We've also had children who then, by doing the adoption, they get benefits through VA if that's what the adoptive parent has any history with the military. Can I change my grandson's name when I do the adoption? Absolutely. So that's something you can petition the court. It just depends on the situation. Some of my clients, you know, depending on the age of the child, sometimes if they're older and let's say they're 14, 15 years old, they may not want to do change the last name to reflect the grandparent's last name just because they're much older and that they're used to that name. But if they're younger, absolutely. So it just depends on the different circumstances. For the most part, we normally just change the child's last name at the adoption, but I have done it for younger children. We've also changed the first and last name. Do I need an attorney to do an adoption? Absolutely. There are so many steps involved in doing adoption, first from the termination of parental rights and then through the adoption process. And there's so many statutory requirements. You want to make sure that you do it right so there aren't any issues later. So it could delay things, but you certainly want to do have an attorney when doing an adoption. Am I required to allow visitation with a child after the adoption? So we get this a lot for grandparent adoptions. So let's say that the biological parents might be in and out of the child's life, but they signed that consent to the adoption thinking, well, nothing will change. It's just a piece of paper. I'll go ahead and continue visiting with the child. And that's if the grandparents or the adoptive parents agree to it. So once the adoption is finalized, that adoptive parent becomes the legal parent of that child and has every right to make any decision related to that child's health, education, financial, and if they decide it's not in the child's best interest to continue visitation with the biological parent, that's their choice to do that. And since the biological parents' parental rights have been terminated, they no longer have any legal right to seek visitation to that child. So my stepdaughter is 16. Does she need to consent to the adoption? This is a great question. So once any child who's over 14 years old needs to be served with notice of the adoption and also needs to consent to the adoption. So for any of the older children that are being adopted, they need to consent and be given notice of the adoption. Once finalized, can the adoption be challenged or overturned? Well, once the adoption is finalized, it's done. So like we talked about in that one circumstance in the termination of parental rights situation, unless you can prove extrinsic fraud, like I said, that is a very high bar to meet and there's a lot of requirements in order to prove that, but it would be such a high level of fraud that you would have to prove, but that's the only way that an adoption could ever be challenged or overturned. But it's my understanding, since the adoption laws were amended in the 80s here in South Carolina, there's been no reported dissolution of an adoption. What if my granddaughter was born in North Carolina? So we talked about that when, as far as who can be adopted, and we said as long as that child is here in South Carolina, regardless of where they were born, you can adopt them. So in this situation, I've had children who were born in North Carolina, but they reside in South Carolina. And so it's pretty simple. The other states will recognize any sort of adoption order from the state. So North Carolina seems to be very familiar with adoptions conducted in South Carolina. So when I've called them and their vital records department as far as how to amend the birth certificates, they seem very familiar with our procedures. So that was no effort. But if it's another state looking to do one for a child born in Michigan right now, I would just call the vital records department in that state and find out what they need from me in order to amend the birth certificate to reflect the adoption. So the adoption would be granted by this state and a court in this state. So the only thing you would need to do with another state would just be amending the birth certificate to reflect the adoption. I've been separated for years, but I'm still legally married. Does that matter in an adoption? It sure does. So as we talked about before in the responsible father registry, any woman who is married in South Carolina, whether they're estranged or not, that her husband is the presumed legal father of any children born to that woman. And like I said, so that adoption makes it will change the birth certificate to show the wife as the biological mother. So her husband would be considered the presumed legal father. So I have a client right now who's been estranged from her husband for 20 years. She's seeking to adopt her grandson. So we're having to get her divorced first before we can pursue the adoption. So like I said, we had already received a couple of questions before today's presentation. So one question was asking about the Indian Child Welfare Act. So the Indian Child Welfare Act is a federal law that was passed in the 70s to protect Indian children who are being forcibly removed from their homes and placed with non-Indian families. So in any sort of court action involving an Indian minor child that is foster care, termination of parental rights, custody, adoption, that child has been identified as Indian, and if that child is eligible or recognized as part of an eligible tribe, then that tribe needs to be given notification of any court proceeding involving that child. So the question says, what happens if when you discover it's an Indian Child Welfare Act case, you contact the tribe and then what? So once you contact the tribe can go ahead and intervene in that court case and have the case removed to a tribal court where it would move forward under tribal court in that case. Or if the tribe does not respond or does not want to intervene, it's my understanding that the best practice to move forward is just to continue giving them notifications of any court proceedings since they have the right to intervene at any time. The other question we got was any info on the steps to adopt my friend's baby that has been living with me since birth would be extremely helpful. I hope that today we've covered what those procedures are. So in this situation, it would depend if the biological parents are willing to consent to the adoption, and if they're not willing to consent to the adoption, whether there's grounds to terminate their parental rights. So that's all that I have for today so far. Susie, I don't know if you're still there, if we've received any questions. I don't see them up on my screen.
I'm definitely still here. We don't have any questions yet, although we did ask everyone to wait till the end to make sure if you covered what their question was asking, which I think this was just a lot of information, such great stuff. And I want to thank you, Charlotte, for walking us through the adoption process in South Carolina. I'll give some information here, but while I'm doing so, if anybody does want to post a question in the box, definitely go ahead and do that. Let me also thank all of you who joined us today. We appreciate your interest in this subject of adoption law in South Carolina, as well as any others. You know, these webcasts on Level Up Law are free legal events, and we do them to educate the public on some of the most commonly faced legal challenges that we see. You can join us every Tuesday at noon for the basics of any particular topic, how to avoid pitfalls and protect yourself and so forth. And you can find this presentation from today and all of the previous Level Up Law webcasts that we've been doing since June of this year on our YouTube channel. Just go to youtube.com and search SC Legal Services and go to our Level Up Law playlist on that channel. Be sure to like and subscribe and sign up for those alerts. That's really important to us. Give us a couple of days to get this one uploaded and you can listen in again. And now, if you have an issue and you need legal assistance and you cannot afford a lawyer, you may be eligible for our free legal representation. And you can see here on your screen the information about how to apply for help here at SCLS. You can call toll-free 888-346-5592 between the hours of 9 and 6, Monday through Thursday. Our intake office personnel are standing by during those hours. And remember also, and this is really important too, you can apply online at lawhelp.org/SC. Now, on that website, we have also quite a few legal resources that are available to you on all kinds of different topics. So please do check it out. Again, I don't see any other questions in the question box, Charlotte. So let me just say again, we thank you for an excellent presentation. We thank everyone for tuning in to Level Up Law, and we do hope you'll tune in again next Tuesday when lead housing attorney Matthew Billingsley will explain how to protect your Section 8 voucher. An easy way to see what's coming up each week is to check out our South Carolina Legal Services Facebook page. You can also follow us on Twitter and Instagram. And also be sure to sign up for those notifications on our YouTube channel so you'll know when these recordings are being posted. All right. Well, that concludes today's webinar. Thanks again to Charlotte and everybody for tuning in, and we look forward to having you back with us next week. Take care, everybody.
Thanks, everybody.